Hey everyone, welcome back to Supreme Court Breakdown. Today, we will be diving into Moyle v. United States.
This case asks a big constitutional question. Does the federal law, specifically the Emergency Medical Treatment and Labor Act, require hospitals to perform emergency abortions, even in states where those abortions are banned after the Dobbs v. Jackson decision?
Let's rewind for a second. In 1973, Roe v. Wade established the constitutional right to an abortion under the right to privacy. This was reaffirmed in Planned Parenthood v. Casey in 1992, but with more wiggle room for state regulations, as long as restrictions didn't place a substantial obstacle before fetal viability. And in 1986, Congress passed EMTALA, the Emergency Medical Treatment and Labor Act, which requires hospitals to provide stabilizing care to anyone experiencing a medical emergency, regardless of their ability to pay. Fast forward to 2022, when the Supreme Court overturned Roe v. Wade in the Dobbs v. Jackson decision. This meant states could now enforce strict abortion bans, and Idaho did just that, passing one of the country's most restrictive abortion laws, the Defense of Life Act. This criminalized nearly all abortions with the exception when necessary to prevent the death of the pregnant woman. So now we're left with a legal collision. Can Idaho's abortion ban override EMTALA's federal requirement to provide emergency care, even if the care involves an abortion?
Let's look at the facts of the case. The Biden administration sued Idaho, arguing that EMTALA preempts state abortion bans when a pregnant person's health is at risk. Basically, the federal law, EMTALA, takes precedence over a state-level law, the Defense of Life Act. The Department of Justice contended that EMTALA requires all hospitals are to provide whatever emergency care is necessary, including abortions, to stabilize a patient's condition even if the patient's life is not immediately at risk but faces serious harm.
EMTALA's promise is simple but profound. No one who comes to an emergency room in need of urgent treatment should be denied necessary stabilizing care. This case is about how that guarantee applies to pregnant women in medical crisis. In some tragic cases, women suffer emergency complications that make continuing their pregnancy a grave threat to their lives or their health. A woman whose amniotic sac has ruptured prematurely, for example, needs immediate treatment to avoid a serious risk of infection that could cascade into sepsis and the risk of hysterectomy. A woman with severe preeclampsia can face a high risk of kidney failure that could require lifelong dialysis. In cases like these, where there is no other way to stabilize the woman's medical condition and prevent her from deteriorating, EMTALA's plain text requires that she be offered pregnancy termination as the necessary treatment. And that's how this law has been understood and applied for decades.
Idaho pushed back, saying EMTALA doesn't require abortions and states should be able to regulate the procedure. Idaho argued that the state law was a legitimate exercise of state power following the Dobbs decision, and that EMTALA did not require the performance of abortions in situations other than those where the pregnant person's life was endangered.
Indeed, EMTALA works precisely because states regulate the practice of medicine, and nothing in EMTALA requires doctors to ignore the scope of their license and offer medical treatments that violate state law. 3 statutory provisions make this clear. First, Section 1395, the Medicare Act's opening provision, forbids the federal government from controlling the practice of medicine. That's the role of state regulation. Second, Subdivision F in EMTALA codifies a statutory presumption against preemption of state medical regulations. And third, EMTALA's stabilization provision is limited to available treatments, which depends on the scope of the hospital staff's medical license. Illegal treatments are not available treatments.
The case initially began in the United States District Court for the District of Idaho. The court granted a preliminary injunction, barring Idaho from enforcing its abortion ban to the extent that it conflicted with EMTALA, and the district court ruled in favor of the federal government. However, Idaho and an emergency petition led by Mike Moyle, the Speaker of the Idaho House of Representatives, appealed the injunction, and the case was rapidly taken to the Supreme Court.
Surprisingly, instead of issuing a final ruling, the court dismissed the case as improvidently granted, meaning they decided not to rule on the merits after all.
So let's break down why the justices felt this way. The court issued for a per curiam opinion, meaning that the court is deciding as a whole rather than a specific author. The court dismissed the writ of cert as improvidently granted. In other words, the court decided it made a mistake in agreeing to hear the case and vacated its earlier stay of the district court's preliminary injunction against Idaho's abortion law. So for now, Hospitals in Idaho must provide abortion care under EMTALA.
First concurring opinions were from Justices Kagan, Sotomayor, and Jackson. They agreed with the dismissal. Justice Kagan stated, "With this court's writ of cert dismissed, the lower courts can proceed with this litigation in the regular course, and with this court's stay dissolved, the district court's preliminary injunction will again take effect."
Justices Alito, Thomas, and Gorsuch strongly dissented. Justice Alito argued that the case was ready for decision and that EMTALA does not require emergency abortions. He wrote, "Apparently, the court has simply lost the will to decide the easy, but emotional and highly politicized question that the case presents. That is regrettable."
To summarize, the Supreme Court decided in a 5-4 vote that the Moyle case should be dismissed.
So, what are the implications of this decision? The dismissal leaves things uncertain. States like Idaho can enforce strict abortion bans for now, but hospitals in emergencies are struck down between federal obligations under EMTALA and state criminal penalties for performing abortions. However, the fight isn't over. More lawsuits are expected, and the Supreme Court would have to revisit this issue soon. But until then, pregnant patients and doctors in emergency situations are left in limbo. And that's it for our breakdown of Moyle v. United States. Thanks for watching.